Hello. In this lesson, we're going to be talking about transfer of ownership. And you might remember from another lesson we talked about the Louisiana Purchase. That painting back there is a painting of the Louisiana Purchase, and that's probably the greatest transfer of ownership that ever occurred here in the United States. So let's get right to it. There's three different methods of transfer that we want to talk about. And the first one is inheritance. The second one is what's called involuntary alienation, meaning a forced transfer. And the third one is voluntary alienation. Now, in this short lesson, we're really going to be talking mainly about inheritance with a little bit about the other two. So let's first talk about inheritance. So when someone passes away, it's likely that one of their relatives or friends, or maybe their dog or their cat, is going to inherit their property. Here's an example of inheritance. And to you, my grandchildren, I leave all my Medicare prescription bills. Well, hopefully that's not all that your grandparents have left you or will leave you. Now, when someone passes away, there's a court proceeding known as probate, which is designed to make sure that the will is valid, if there is a will, or even if there isn't a will, that the property is distributed according to law. So probate is the court proceeding designed to distribute a deceased person's property. And if a person dies with a will, they have said to have died testate, with a last will and testament, so they've died testate. And if they pass away without a will, they are said to have died intestate, meaning without a will. Now, if there is a will, and the will states that there's a specific person or persons that are going to make sure that the property is distributed according to the provisions in the will, that person is called the executor. So an executor is a person named in a will to carry out the provisions of that last will and testament. Now, sometimes a will may not mention a person to carry out its provision, or if someone dies intestate, the court has to appoint somebody. So in either case, when there's nobody named in the will, or when there's no will at all, the courts will step in the probate process and name an administrator. So an executor is someone named in the will, an administrator is someone that the court appoints to carry out the provisions of the probate. Now, in today's world, both of these persons are often called a personal representative, but you should know that term as well as executor and administrator. Now, there are a number of different types of wills that we want to talk about here, and the first one is simply a standard will. So a standard will would typically be the will prepared by an attorney for an individual. The second one is called a holographic will. These are relatively rare, but a holographic, holo meaning completely, graphic meaning written, is a handwritten will. So there are occasions where someone will actually take the time to write out a will in their own handwriting, and that will is referred to as a holographic will. The third one is called a nuncupative will. And a nuncupative will is basically an oral will, typically a deathbed wish. So the large majority of wills would be standard. There are some holographic wills, and we have rare occasions where we have a nuncupative will or an oral will. Now let's talk about the different types of inheritances. You've probably heard some of these before, but this one you probably have not heard about, and that's a devise. A devise, D-E-V-I-S-E, is a gift of real property through a will. So let's say your grandmother passes away and she wills a piece of real estate to you. That is called a devise, and your grandma would be the devisor, and you would be the devisee. So a devise is a gift of real property through a will. Then there's what's referred to as title by descent. So let's say your grandma passed away and she had no will. but you were the sole heir to her estate. In that circumstance, since you are the not the defendant, the descendant, you're not a defendant, you're a descendant. Since you were a descendant of your grandmothers, then that property would be transferred, what's called title by descent. The third one and fourth one here is a bequest or a legacy. Oh, by the way, let's go back to descent. Both devise and descent mean a transfer of real property either through a will, a devise, or because of the specific state statutes that name someone as a descendant. But devise and descent deal with real estate. Bequest or legacy is a gift of personal property through a will. So a bequest and legacy imply personal property, whereas devise and descent deal with real property. So that's our little discussion on inheritance. The next type of transfer is what's known as an involuntary alienation, a forced transfer, in other words. Pardon my little dark humor there. So involuntary alienation typically falls under three categories. The first being eminent domain, the right of the government to take private property for public use with compensation, the process being condemnation. Eminent domain would be a forced transfer or an involuntary transfer. The term alienation, remember, means transfer. The next one is adverse possession. Adverse possession is the process of giving rise to ownership by someone squatting on a property, using a property for a long period of time. And the third one is foreclosure. Now, we haven't discussed or are not going to discuss foreclosure in this lesson, but we will discuss that in detail in another session. So the three methods in which property is involuntarily transferred are eminent domain, adverse possession, and through various foreclosures. Now, the last one here we want to talk about is voluntary alienation. Most transactions are voluntary. So a voluntary alienation is a voluntary transfer. So a typical sale, the large majority of property transfers occur between a buyer and a seller. That would be a voluntary alienation. It's an uncoerced, unforced transfer of ownership. And of course, the document that transfers ownership is a deed. And in all of these circumstances, by the way, whether it's an inheritance, where eventually through probate a deed would be executed, or whether it's an involuntary alienation, a deed would typically be used in those circumstances, and certainly in a voluntary transaction, a deed would transfer ownership. So that's it on our brief discussion here of transfer of ownership.